Welcome to Mental Disabilities and the Criminal Justice System. I'm Elizabeth Kelley. I'm a criminal defense lawyer, and I specialize in representing people with mental disabilities. On this podcast, we provide information and hope to people with mental disabilities caught up in the criminal justice system, as well as to their families. This episode is part of a series where we will talk with various authors who wrote chapters in the upcoming second edition of my book, Representing People with Mental Disabilities, A Practical Guide for Criminal Defense Lawyers, published by the American Bar Association. In this episode, I am talking with Zach Segal, an attorney at the law firm of Levitt & Kaiser in New York City. Zach, along with his law partner, Richard Levitt, wrote the chapter on post-conviction relief in the second edition of my newly released book, Representing People with Mental Disabilities, A Practical Guide for Criminal Defense Lawyers, published by the American Bar Association. Welcome, Zach.
Hi, how's it going, Elizabeth?
It's going well. Thank you for consenting to do this interview. And more importantly, thank you for the wonderful chapter which you and Richard wrote for representing people with mental disabilities. And as I was rereading that chapter in preparation for this conversation, I thought, this is a document which I am going to share with my clients and their families. And the reason why I say that is not only is it substantive, but it is very, very accessible. And you and Richard take some tremendously complicated legal principles and make them accessible to the ordinary reader. With that in mind, Zach, tell our listeners, what do you mean by post-conviction remedies?
Sure. So thank you, of course, for having us on again. Richard couldn't make it, and obviously I'd be foolhardy to not mention that, without Richard teaching me how to really be a lawyer, I don't think I'd be in any position to have put something, or at least assisted in putting something together. That said, so what do I mean about post-conviction? So legal terms, post-conviction is the time after your direct appeals have been completed. So what are direct appeals? So in the ordinary course of things, someone gets charged with a crime and they either plead guilty or they're found guilty at a trial, and then there's a sentencing. After the sentencing, then this person could what's called file a direct appeal, and they would file that to an appellate court. And if the appellate court denied relief, which unfortunately it happens more often than not, then the person can seek discretionary review from the Supreme Court. We're going to operate in federal world, so discretionary review from the Supreme Court of the United States. And then after the Supreme Court denies review, then you're in what's called post-conviction world. So any challenge against either your sentence or your conviction after the Supreme Court's denied review in that first round of appeals is called post-conviction.
Got it. And your chapter focuses on two general kinds of post-conviction remedies, 2255s and motion for compassionate release. Very broadly, what is a 2255 and when is it filed?
Sure. So there's a 2255 and a 2254. So a 2254 is filed by state prisoners. So a state prisoner having gone through the state court system, after he's gone through all of the same appeals to the state's highest court, can then go to federal court and then say, hey guys, the state courts violated my constitutional rights. Ditto for a federal defendant. Those claims have to be filed within 1 year of your conviction being filed. So for the state court prisoner, it would be after he's gone to the state's highest court and was denied relief. And for the federal prisoner, it's after the Supreme Court's denied relief.
And to clarify for our listeners, the 2254 is the state proceeding, and the 2255 is for the federal proceeding, or more accurately, the 2254 applies to state defendants and the 2255 applies to federal defendants, correct?
Correct. Yeah. So a state prisoner filing a 2254 is going to be in a state prison, and a person filing a 2255 is going to be in a federal prison.
Now let's focus in on the reason for the book and the reason for your chapter. The special challenges that people with mental disabilities face in filing a 2255 and a 2254. What are some of those challenges?
The sum of those challenges were the same. The sum of those challenges are the same for really everyone. The first thing that you need to overcome is you need to file within a year. That's mission number one. And that's a statutory rule. These claims need to be filed within 1 year of your conviction being final. The second one, which applies more so to state prisoners, there are certain instances when it could apply to a federal prisoner, but a procedural default. So in order for a state prisoner to file a 2254 in a federal court, he's going to have to have, he or she will have to have raised those issues in state court. In other words, he or she will have had to given the state courts an opportunity to have reviewed those claims before going to federal court and saying, hey guys, the state courts violated my constitutional rights. So those are the
Now, do courts give any special deference or any special consideration to people who have mental disabilities if they miss those very precise deadlines?
Thankfully, yes, they do. And those are the subjects of the chapter. So the chapter first starts by, explaining the nuances of 2255 and 2254, as we went over briefly before, and then gets into how a mental disability, or if a mental disability, can be used to excuse certain of these very strict filing deadlines, or very strict filing rules. So the first one, the 1 year rule, that's subject to what's called equitable tolling. So as I was saying before, you have 1 year to file from the date your conviction becomes final. But that 1 year can be equitably tolled. So the courts use the word equitable, I guess, because the reason generally centers around notions of fairness. So in other words, it would not be right to preclude you from filing. And so to make that showing, to toll the 1 year, so let's say you're beyond the 1 year and you file, it has to be based on, one is newly discovered evidence, and the other is due to extraordinary circumstances. So the extraordinary circumstance one is where mental disability comes into play. And to obtain equitable tolling of the 1 year statute of limitations based on, and this is the words used by the courts, it's mental incompetence. The prisoner must, or the petitioner must demonstrate that he is, one, mentally incompetent, and that his mental incompetence caused his failure to comply with the statute of limitations. Some courts have laid out a non-exhaustive list of factors to figure out whether someone meets that demanding standard, and that's whether the petitioner was adjudicated incompetent, and if so, whether the adjudication occurred in relation to the habeas statutory period. The second is whether the petitioner was institutionalized for his mental disability. The third is whether the petitioner handled or assisted in other legal matters which required action during the federal limitations period, and I'll explain why that's important later on. And the fourth is whether the petitioner supported his allegations with extrinsic evidence, such as evaluations or medication. So basically what the courts are saying is, if you can show us conclusively that you suffered from some sort of mental disability, and that mental disability caused you to miss that 1 year deadline, we're going to give you the opportunity to file, and we're going to excuse your lateness, I guess is the right word. And these cases are far and few between. There was one instance where a petitioner, he suffered from severe delusions. And so that was uncontested. That was proven that he suffered from those delusions. But the interesting part about it was that these delusions were that the case had to be seen to its end before he can even go back into court. So what ended up happening was the courts said, so the first thing they said was on the severity prong, the severity of the mental illness, was that various doctors throughout the relevant period opined that this person suffered from severe delusions, and it was documented that he would believe that he was working for the FBI. And then they said, and it was impossible for him to comply with this because his delusions were that he had to see the case through. So in other words, his delusions precluded him from timely filing the petition.
Well, that's
And so,
fascinating.
yeah, it was an interesting case. You would think a decision like that would be a little bit longer, but the court managed to get through it pretty quickly. And actually he was denied relief in the first instance by the district court, so the first federal court to hear it. And then the appellate court said, well, that makes no sense. You've said that this guy had all these delusions, that they were that severe. So how can you, on the other hand, say that these delusions don't excuse his untimely filing? Anyway, so that was one instance where.
No, that careful reading by the court is encouraging. Now, Zach, too often I have families come to me after their loved one has been convicted. Their loved one has a mental disability, and they blame the lawyer for all sorts of things that they think what went wrong. Does a 2255 provide any sort of relief in those circumstances for what is commonly called ineffective assistance of counsel?
They do, but before I get there, I just want to make a note that there's something called another excuse for failing to exhaust is if you have what's called a substantive competency claim. So that's basically showing you were incompetent to be tried, period.
Okay.
And in those scenarios, a couple of the circuit courts will always excuse your late filing. So turning to ineffective assistance of counsel, yes. So the short answer is yes. There are a handful of reasons you can obtain post-conviction relief due to your lawyer's failures with respect to a mental disability. So the first I would want to mention is just a sentencing counsel's failure to investigate mental health. So backtrack a little bit. At a sentencing, a judge is subject to certain mandatory minimums where the judge doesn't have discretion. They're allowed to really consider anything in sentencing you, and they can base their sentence off of, a whole host of factors. In the capital sentencing realm, so death penalty realm, there's the trial where you're found guilty or not guilty, and then there's a separate, I guess, mini trial for guilt. For punishment, whether the person should get the death penalty or should be sentenced to life imprisonment. In the capital context, the sentencing counsel's failure to investigate mental health is cognizable. In non-capital cases, it's unclear. It's kind of like this void that hasn't really been filled yet by the court. So it's leaving people unsure whether you can raise these claims, but there are a handful of claims that you can raise, and I'll go through them now. So one of them is failure to investigate mental illness at a sentencing and then move for a departure under the guidelines. So the guidelines, basically, they give the judge a range of where to sentence you based on an intersection between your offense conduct and your criminal history score. So there was a case out of Iowa in 2013 where a judge, he upwardly departed. So he went higher than the guidelines because the defendant during trial, I don't know if it was during trial or just during the proceedings, he had these violent outbursts. And the judge said, sum and substance, this guy is violent, he can't control himself. I have to put him away for longer than what the guidelines suggest. And the defendant years later came forth with evidence that he suffered from something called intermittent explosive disorder. And the judge said, well, Mr. Lawyer didn't present that to me at sentencing. And the only reason I gave him more time was because of his violent outbursts. But this disorder explained the violent outbursts. So I'm going to find his lawyer was provided ineffective assistance. So ineffective assistance, I should probably explain the Sixth Amendment guarantees everyone a right to the assistance of counsel. The Supreme Court has said that includes the effective assistance of counsel. So counsel is ineffective if it's two tests, or two prongs. So the first one is whether your lawyer's performance was objectively unreasonable and whether you can show prejudice as a result. Prejudice is really a reasonable probability of a different outcome. So applying that test to the case we were just talking about, it was objectively unreasonable for that defendant's lawyer in that Iowa case to not bring up his client's disorder, and he suffered prejudice because the judge said if the lawyer would have presented it, there's a reasonable probability that he wouldn't have given him a sentence on top of the guidelines. Another instance is where a lawyer fails to request a competency hearing. So as a preliminary matter, and we'll get into this a little bit more below, and we talk about it throughout the chapter, as a general rule, someone who is incompetent, and that's the legal word, suffers from mental disability, can't be adjudicated guilty. I can give you the exact language from the Supreme Court. It was the test is whether a defendant has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against him.
And for the benefit of our listeners, that's taken from the Dusky case, which was decided in 1960. And
Yeah.
that's basically a nationwide standard for
Exactly.
Competency to proceed.
Exactly. And so if a lawyer fails to request a competency hearing, what the defendant would have to show is that, there was one really good example where the defendant gave his lawyer a packet, like a thick packet full of information that showed that the guy had a mental disability, and his lawyer didn't make a motion for a hearing. Nothing happened. And so the courts on post-conviction review said, all right, well, if he would have done this, there's a reasonable chance of a different outcome. And actually, there was one appellate court in the Fifth Circuit based out of New Orleans, which said, in these situations, if you can show that the defendant was incompetent, then naturally he was prejudiced because an incompetent person can't be found guilty. So prejudice is presumed.
Sure.
Another instance where a lawyer can be ineffective is at a competency hearing itself. So a lawyer who fails to cross-examine the government's only witness. And in that instance, he failed to cross-examine the witness, and then he actually agreed that his client was competent, even though there was tremendous evidence to the contrary that the client was far from competent. And the appellate court, it was the Third Circuit out of Philadelphia, said, well, no, you agreed with the government, so you didn't even put up a fight, and you didn't cross-examine them with any of the information you had at your disposal to show that the guy really was incompetent.
And I want to pedal back for a moment, because simply because someone has a mental disability does not mean that they are per se incompetent. And most lawyers know that in practice, the competency standard is very low. That being said, there's usually something you can do with a mental disability, some way to make it matter. And it sounds like these courts on appellate review are saying the same sort of thing.
Yeah, they really are. I mean, they're, where it gets wonky and it gets really frustrating is we can talk about it maybe in a little bit, but something called a Feretta claim. So you have a right to self-representation. You have a right to represent yourself. So, but when there's a cross-section between, whether you're competent to do so. So the question of Feretta claim would be, and this you can just raise absent your lawyer, without claiming your lawyer's screwed up, is you would look at the competency standard under Dusky. And the second question is whether there's a knowing and voluntary waiver. What's interesting is so the courts have said someone who's deemed incompetent to stand trial, the court's going to appoint a lawyer over his say so and basically say, no, you're not allowed to represent yourself. You're incompetent to represent yourself. And we're going to appoint a counsel. We're going to appoint you a lawyer to proceed. But where things have gotten kind of weird in this area is they haven't. So it's a lawyer who's competent. So a defendant who's competent to stand trial from one who can represent himself is this kind of gray area where the courts haven't really figured out what to do. So how can you be incompetent to stand trial, but not incompetent to represent yourself? It's this weird dichotomy that the courts really haven't squared up yet.
Yeah, and most practicing lawyers will tell you that the skills that are needed for entering a guilty plea may be different than the skills are needed for assisting at trial, but is that further the same set of skills which are required for admission to a mental health court? It's all a very long way of saying that arguably the courts have not caught up with the developments of science and medicine.
It's one way of saying that. Yes, I
Yeah,
agree.
yeah.
There are other instances, where the courts have kind of caught on, and that's, another area where you can blame your lawyer is if your lawyer fails to pursue an insanity defense. So if your lawyer objectively could have figured this out and there's no other defense available, then your lawyer can be ineffective for failing to do that. And the same for intoxication. I think, Elizabeth, you would know better than me, but I think intoxication or alcoholism and substance abuse are now on the DSSM, are they? They on
The
like
DSM, correct,
yeah.
correct.
So when the defense is available for intoxication, for example, a lawyer can actually be found ineffective in failing to pursue that. Failing to pursue an intoxication defense to show that your client didn't have the mental, I guess, acuity to intend his conduct. Another interesting
And
thing,
as we know,
yeah,
for many of those individuals, they have a co-occurring mental illness, and it's sometimes difficult to know where the mental illness ends and the substance use begins. And indeed, they are bound together. Zach, I want to finish up by talking a bit about compassionate release in the federal system.
sure.
What is compassionate release? And what are the legal standards that need to be shown?
Sure. So what is compassionate release? Compassionate release is the best way. So it's codified at 18 USC 3582 C1A. It allows a federal prisoner to file a motion before his previous sentencing judge for a reduction in sentence. Before November 2023, well, if you want to really take a real history lesson, we can go back. And it was between 1984 and 2018, the Bureau of Prisons was the gatekeeper to the federal courts. After they did nothing, they barely filed motions, they barely filed claims for people. And a lot of it had to do with medical issues. Before I went to law school, I actually had the opportunity to file or work with the BOP to try and get people relief under this, or to convince the Bureau of Prisons to file a motion on someone's behalf. We had clients who were dying of cancer, and although the facility where the person was incarcerated was telling the Bureau of Prisons, the higher ups, that, look, you should file, we recommend that you file on this guy's behalf. He's going to die within, a couple of weeks, couple of months. They would keep getting denied. Come the first step back in 2018, that changed, and that allowed criminal defendants, after waiting 30 days, well, filing with the warden or asking the warden to file, and then waiting 30 days to go into court on your own, and make the motion yourself. So after between 2018 and 2023, there was although the Sentencing Commission had a list of what can be called extraordinary and compelling circumstances, and that's the standard you need to meet to for the judge to consider reducing your sentence. That list, the court said they're outdated, that it's not caught up with the new laws. So we're going to consider whatever we want. And in those years, they were considering, well, with respect to mental disability, they were considering the ability to obtain treatment, mental health treatment in jail due to the COVID lockdowns. There was a handful of cases where, the court's defendant, or even the courts at the original sentencing were saying, look, I want you to have specific mental health treatment or even drug treatment. And due to the lockdowns, the prisons weren't able to provide them. So the courts were just reducing this person's sentence. Increased risk or COVID, also to do with COVID. So increased risk of bad outcomes. So for example, there was one instance where a defendant's mood disorder increased the likelihood of a bad outcome should he contract COVID. And, CDC guidance said that according to the CDC, for one person, there was PTSD and depression placed someone at the risk of increased complications. And the court said, well, this person obviously suffers from those. And so we're going to grant him, we're at least going to consider reducing his sentence. And then they looked at the sentencing factors to actually reduce the person's sentence. The third most common, and I was saying before that the policy statement wasn't binding until 2023. Since then, the Sentencing Commission finally got a quorum together, and they laid out a list of circumstances that can be extraordinary and compelling. So they're terminal illness, debilitating physical conditions or mental conditions, victims of
And
abuse.
Zach, I'm going to interrupt you. For clarification, in 30 seconds, what is the U.S. Sentencing Commission?
Sure. So the U.S. In 30 seconds. So the U.S. Sentencing Commission was a body. It's not really part of I guess you can call it even a fourth branch. It's not really part of the executive, judiciary, or the judicial branch. So Congress created it to put together, as part of the Sentencing Reform Act, a guide to determine how people should be sentenced. The Congress in the 80s figured that, or opined that people were kind of being sentenced differently based on different jurisdictions and different whims of different judges. So there was no real expectation of punishment, what a certain sentence would be. So they created a Sentencing Commission to put together a guide which would ascribe points for criminal history and for offense conduct that would result in a guideline range, which the court was required, subject to certain exceptions, to sentence the defendant within. Fast forward to 2005, the court said, nah, you know what, come to think of it, maybe we should give I'm paraphrasing, maybe we should allow the judges more flexibility and not require them to be bound by these sentencing guidelines. And so we're going to let them consider, go beyond the guidelines and use the guidelines as kind of the word for it, as their guides. The Sentencing Commission also relevant for compassionate release issues. So Congress is part of the statute that allows a prisoner to bring compassionate release, directed the Sentencing Commission to come up with a policy statement for what circumstances are extraordinary and compelling. And they did that. And now with that new policy statement that's updated and finalized in 2023, one of the circumstances that I guess relevant here is, in addition to a debilitating mental health condition, is neglectful medical treatment. And courts have found Bureau of Prisons' failure to provide adequate mental health treatment to be, quote unquote, extraordinary and compelling, which would allow the court to consider a reduction of sentence. So
Got it. So that was a little bit longer than 30 seconds, Zach, but all of it useful, all of it relevant. So would it be accurate to conclude that now that the pandemic is over, people with mental disabilities who are in federal prison can and should first file a motion with the warden of their institution, then after 30 days, if they have not heard, or if the warden has denied, They can then file with the district court judge who sentenced them. And based on a variety of different circumstances that constitute extraordinary and compelling circumstances, including neglectful medical care, they might likely be released.
I wouldn't go as far as saying likely, but it'll definitely be cognizable.
Beautiful.
I'll
Beautiful.
give you one instance where the government actually joined a defendant's motion. So the defendant, this was in court out in Oregon, the defendant suffered from schizoaffective disorder and anxiety, conditions which had been previously successfully treated based on an antipsychotic medication. But once the guy got into federal custody, he wasn't receiving the dosages necessary to stabilize his condition, even though the prisoner's lawyer and the prosecutors were asking the Bureau of Prisons to give him these medication. The Bureau of Prisons refused to administer the required dosages, causing auditory and visual hallucinations, insomnia, general panic. And together, the defendant's lawyer and the government moved for a reduction of this person's sentence, and it was granted. And he was
Beautiful.
granted the
Beautiful.
day, actually, it was actually granted the day of the filing. And
Yeah. Yeah. Well, Zach, your knowledge of this area is encyclopedic. Thank you for spending time with us. And again, thank you for the magnificent chapter on post-conviction remedies as they pertain to people with mental disabilities, which you and Richard, your law partner, wrote.
thank you, Elizabeth, for thinking of us to do this, and of course for publishing such a wonderful book. We look very forward to seeing the final version, and of course to sharing it with our clients, who do not doubt will benefit greatly from everything in there and
I
everyone else reading
appreciate.
it.
And by the way, the book came out late last week, and you should be receiving your copy in the mail in a matter of days.
Lovely. I look forward to showing it to my soon-to-be newborn son, who's going to be coming in a week. So if he ever asks what Daddy did, at the very least, I can say I co-authored a chapter in a book.
And congratulations in advance. Take
Thank you
good care,
very
my
much.
friend.
Yes, ma'am. Take care.